Okay, come on up quick. Okay, so we have another witness. Detective Ramos is going to retake witness, but there are a couple matters I have to take up with the attorneys outside of your presence. So I'm going to have you all step into the jury room, and then we'll be with you shortly.
All rise. All jurors are out, Judge.
Okay, very good. Okay, so we'll take a 5-minute break and give Ms. Ismer a chance to get organized.
Ms. Doherty's going to pull the exhibits. If Your Honor wants to do the motions, I'm prepared to
Okay.
start whenever the court is.
Okay, sure. Okay, so I guess for the record, it would be helpful if you have the proposed exhibit numbers, and if you could just put the exhibit on the Elmo so I can make sure I'm talking about the same thing as you all. Okay?
So,
Okay?
begin, Your Honor?
Yeah?
So you're referring to Defendant Rashad Murphy's 7th motion in limine, which now has changed a little bit because we're referring to, instead of what was previously Exhibit 65, it's now Exhibit 101.
Okay, let's
And-
put it up on the, so I can see it.
Yes, and Exhibit 101, Judge, is a cell bite extraction of the jointly possessed phone, 904-386-0925. First, Judge, would be State's Exhibit 101R.
Okay?
And obviously, this photograph depicts Mr. Murphy face and upper torso. I would certainly argue that this is not relevant, it's not admissible under 401. If there is any relevance whatsoever, it is outweighed by the extreme prejudice that would exist. Certainly, what appears to be Mr. Murphy's smug or otherwise maybe indicative of a lack of remorse after Mr. Jones's homicide. These facial expressions, I think, give rise to a significant risk that the jury will interpret this appearance as reflecting some sort of character that he's exhibiting or some type of consciousness of guilt. And I don't, A, understand relevance, and B, certainly would not suggest that it's outweighed by any prejudicial value.
Any probative value. Okay, so it looks
Probative
like,
value.
according to the records, it looks like this image was created June 25th of 2024 at 3:04:21 UTC time, correct?
Correct, Your Honor.
So what's the relevance, Ms. Ismer?
Your Honor, in this picture, the state's not asking for any witness to determine what the significance of the defendant's facial expressions are, but instead to assert the defendant's possession of this device, his wearing of the clothing that is depicted in the Walmart footage before the homicide, and in this description or depiction from after the homicide. It certainly puts the defendant, even with having a cap on and the jewelry and the black top, in the same position, same clothing he was in Walmart as well. I understand that the defense's argument is that it is a shared device, and that's fine, but there are dozens of posts that come from what the state is asserting is this device over the course of this 5-day period. So it is an item or an exhibit asserted to establish the defendant's possession of this device thereafter.
Okay.
No one's asking the opinion of what the face means.
Right. And I would note, I mean, there does appear to be some religious jewelry on there, so that could be helpful to your client as much as.
Judge, I'm certainly not looking at the religious aspect of it being helpful to Mr. Murphy, but certainly the fact that he's wearing a black T-shirt and a beanie would have, in my eyes, zero relevance to anything that occurs with regard to this murder, whether it be what shooter number one is wearing, or what he's wearing at Walmart. We've never insinuated in any way, shape, or form, based on our questioning, based on the answers that we are eliciting, based on what was said to the jury in opening, that phone is not a jointly owned or jointly possessed phone of Rashad Murphy. In fact, it is part of our case. So for the state to suggest that this is necessary because of some clothing relationship, I think the fact that it's a black T-shirt and what appears to be some kind of a black hat is wholly insufficient to suggest that it's relevant. And certainly even the look, and just the look on Mr. Murphy's face, lends itself for the jury or to the jury to have any number of different type conclusions. This is June 25th. It's 2 days after the murder, and certainly is not affixed with any other type of comment or post that might create context. I think it does nothing more than present or paint a picture for the jury of what type of character Mr. Murphy has, simply based on the look on his face, and it would lend itself to that. I can't imagine it wouldn't.
Okay. All right. Well, I do find it's relevant, and I find that any prejudicial effect is outweighed by the probative value. So overrule the objection. You can admit it. Okay. What's the next one?
Next would be states 101J.
Okay. What is that?
Your Honor, 101J,
Yep.
and I can't get it all. Well, I can. I know what I'm doing.
Well, that's fine. I just make sure I'm looking at the same copy. It appears to be someone's right arm and a car in a driveway.
Yes, Judge. It looks like the associated date is the 20th of June.
Right.
At 7:16 p.m. UTC. I believe the state's going to intend to argue that this photograph is Charles Jones' vehicle. I don't know that there's going to be any evidence that this is in fact Charles Jones' vehicle.
Right.
Or any identification of the person who happens to be in the partial picture, or what address that is and where it's at and what relevance it may play to Mr. Jones. Again, I think the state would assert, well, it's a couple of days before the murder, and
Well, let me hear
it
from the
exists-
state then, so.
I'm sorry,
Let me
Judge?
hear from the state then what the relevance is, okay?
Judge, the exhibit posted in 101J was a photograph that was sent with another photograph at the same exact time and same exact second, which depicted the victim. There are also identifiers on the vehicle which are specific to the victim, or at least similar in nature to the victim's vehicle, including the hood, the bumper itself, the lights, the grille, but most importantly, it is sent in essentially a text message, 2 pictures, really 6 pictures with other context that Mr. Gonzalez is aware of, but the pictures do include photographs or a photograph of the defendant, the victim in this case, on the defendant's device. So
And-
certainly relevant to each other.
Okay, and they were sent either to or from the joint phone, the jointly owned phone with Ms. Steiger?
Yes.
Okay.
Judge, the additional argument here is that there's no, in addition to there being no foundational evidence to establish the vehicle ownership, I think simply saying that generally it's a black car that may or may not be a Charger that has similar features doesn't get us any closer to determining whether or not it's Mr. Jones' car and it's relevant. I think in addition to that, Judge, it's the same argument that it's recovered in a part of the phone which is a system generating cache. It's an area where I don't believe the state can testify that Mr. Murphy even ever saw this. The fact that it's in the phone, it's in the extraction, it's in an area, it's in a place that it could have been generated, it could have been in that cache, and I don't believe there's any means to determine whether or not it was ever viewed by him or whether or not he knew it was there.
Well, it sounds like your cross of Detective Ramos and your argument for the jury. What's your response, Ms. Ismer?
Your Honor, there's a source file path associated with these images that has been attached to the exhibit itself, and these images were located in the mobile SMS or text messaging data of the device. So the state can authenticate these images as well as have the officer the detective, testify about their authenticity.
All right, again, I do think it's relevant evidence, and really, this goes to weight, not admissibility, so. All right, overrule the objection, be admitted. Next.
Judge, next would be 101C.
What is that?
This is 101C, Judge.
Is it the profile photo, the purported profile photo? Huh?
Yes, sir, and that is what the state extracted it as. I don't know what app it is from because I do not have that information, candidly.
Okay.
On what account, essentially.
And is that so anyway, state, tell me why you need this. Why is it relevant?
Only because of the content in the photo, Your Honor. It is obviously believed that the subjects or suspects in this case were utilizing face, head coverings, and gloves, and what would appear to be the defendant is taking a photograph of himself or some kind of a selfie on the 17th of June at 5:30 in the morning. In advance of our homicide, charged conspiracy dates beginning of June before the date.
Judge, first of all, I don't think the state can identify that that's Mr. Murphy taking a selfie of himself. Okay, that's the first thing. The second thing is the fact that this person's wearing gloves and a hood doesn't in any way, shape, or form comport, even if you look at the picture, with what was being worn by shooters that were 6 or 7 days later. Again, whatever limited relevance it may have is certainly outweighed by its probative value. It's on the phone, and that's the end of it. If they could see a face and it's Mr. Murphy, or it's Mr. Murphy's profile picture on Mr. Murphy's account, one of his accounts, that would be another story.
Do you have any evidence, or can you link it up to any account that's?
I do not have any kind of source or file data that says what account it came from, just that it is in the mobile library images of the device.
All right. Okay, as to this one, at this time, I'm going to sustain the objection. Now, if something, Ms. Ismer, you think the door gets open somehow or it becomes relevant, we can readdress, but at this point, I'm going to sustain the objection. All right, what's up next?
Judge, we would be moving now to State's Exhibit 88. 88, Judge, and I believe that it would be, bear with me 1 minute. '88. I don't. Which one is it? This is the one that's getting.
88, 1 through 11 you listed. B, 80B, and then D, 1 through 11.
Judge, in 88B, this appears to be an Instagram communication between an unknown individual named John Wall and an account Ghost187 underscore. 12:38 a.m. on the 23rd of June, with the body stating, "Get the B&B for me, gang." Again, Judge, I would object as to its relevance and how that relevance might be outweighed. We do not know who John Wall is. We do not know if there are subsequent or prior conversations that would provide context to this particular singular post and response, and therefore I would suggest to the court it's not admissible.
Okay, what's it relevant to?
Your Honor, the account's been identified by multiple witnesses at this point as belonging to Rashad Murphy, messaging another individual 3 hours in advance of the homicide having occurred for the Airbnb information. And this message is sent minutes after the victim is posting to his Instagram, actually just a minute after the victim has posted to his Instagram account that they are at an Airbnb. Also, several hours throughout the day after the victim has been posting, and other individuals from the Airbnb have been posting about a party at the Airbnb in Tampa.
Just short follow-up, Judge. First of all, I would suggest that although there has been testimony with regard to Ghost187 being an account that's associated with Mr. Murphy, no witness, every witness that has been inquired of has suggested they've never seen a picture of him on that post. They've never seen anything related to him on that post. They've never seen him, they've never seen a family picture, a child picture, anything that would associate him with that Instagram account other than just simply saying it is. And I don't think it is sufficient.
Well, again, that sounds like your argument for the jury. I'm going to overly objection, be admitted. I find it's relevant, and the probative value outweighs any prejudicial effect. Okay, next.
Judge, I can take the next images, and I guess we'll have to go through them individually, but what I will do, Judge, is simply say that the argument is the same.
Okay.
I'll make the argument initially, and apparently these images range from June 14th to June 25th, as the court sees them. And again, I would make a 401 and 403 argument to them, collectively as well as individually, that the relevance does not exist, and therefore, if there is any relevance, it is outweighed by the probative value is outweighed. And I would start, Judge, with 88D1.
What am I looking at? A photo of whom?
Judge, I'm trying to get it to where you can see the
No, I have the copy. I just don't know who I'm
okay.
looking at.
okay.
Prosper Johnson and Joe Rod Adams.
Okay.
We expect argument from the defense in this case that the defendant's deleted posts after this homicide include some reference to, instead of 187 babies and Prosper and Junior being the murdered victims of gun violence, that it makes some reference to the defendant's children. This establishes the defendant has knowledge of these other individuals, and obviously was posted in sequence with the other events that have occurred in this case. So it's certainly relevant to establish his knowledge of these other individuals. The state also has sufficient rebuttal evidence to establish the birthday defense would not suffice. So certainly relevant to the state's case in chief, and also specific rebuttal evidence if needed.
Okay, very good. Overrule the objection, be admitted.
Next, Judge, would be State's D2.
If I may, D2, 3, 4, and 7 have already been published through the recording, and I believe Mr. Gonzalez is in agreement that those have been at least admitted in another fashion in this case.
Judge, note my objection. They have been admitted. They were objected to at that time.
Yep.
And I want the court to renew the objection. And that was D2, D3, D5,
Four,
D4,
and D7.
Judge, next would be
Okay, so those will
D5.
be, those have already come into evidence, and I had overruled the objection, so they will remain admissible.
D5, Judge?
Okay? That's the quote from Sun Tzu? I'm not sure who that, I can't read here. Anyway, what's the relevance?
Judge, this is posted in a series of Instagram posts just after the celebratory post, including the one with the middle fingers from the defendant, and to be followed immediately by the Prosper and Junior G-Day Today posts and Hate Me Kindly posts. This is ultimately just to complete the posts from the morning after the homicide. Date and time stamp on this post relevant to our case would have been 10:52 a.m. on June 23rd.
Overrule the objection, be admitted.
Next, Judge, is the post that Ms. Ismer was referring to just prior in her same argument. D6.
Okay. Overrule the objection, be admitted.
D8.
What's that a picture of?
A still image of Joe Rod Adams, the individual referenced in the earlier photo by the defendant, also the individual that was killed in the homicide.
Okay.
Robert Howard pled guilty to.
And that was posted June 24th, correct?
Correct, Your Honor.
Okay. Overrule the objection, be admitted.
D9.
Same argument from the state, Your Honor.
All right. And that was posted.
I'm sorry, same argument being the relationship in time?
Relationship in time to the other post and relationship to specifically the content of the other posts.
Overrule the objection, be admitted.
D10.
And 11 are both images posted, in relatively close time to each other. Both posted relating to individuals related to the case. Individual in D10 is the individual whose account is linked to paying for the Airbnb. Individual in D11 is the individual who is the author of the Foolio Dead music video. Both of those music videos posted to YouTube on the 24th and 25th, and the defendant immediately reposting those to his account. Both make references to, or at least the J. Breezy video makes reference to this particular murder. I could not tell you about the lyrics on Gravedigger. I have not memorized those.
Judge, my only additional argument there would be simply the fact that these are posted in the within the 2 days of the murder. There's no direct reference to the murder. These individuals are not related to the murder. They're not suspects in the murder. They're simply, as thousands of other individuals do, they follow drill rap videos. They post them. They share them. And I don't think there's any relationship to the crime and the offense at hand.
All right, well, again, that sounds like your argument that you would make to the jury or cross-examination of Detective Ramos. Overrule the objection, then come in. Okay. Any other exhibits, proposed exhibits that you object to? Have we talked about all of your objections? Mr. Gonzalez.
Judge, that covers the motion in limine number 7.
Okay.
Everything would be ruled on. We do have one more issue, Judge, and that is I had previously sought admission or told the court that I was going to be seeking admission to
Right.
the text message that was screenshotted, text message communication that was screenshotted and on the extraction of the jointly owned phone.
Are you maintaining that, or are you withdrawing that? Because originally it was kept out due to the fact that it could be deemed improper character evidence, right? This looks like a conversation where someone is discussing how to smuggle a contraband cell phone into a prison, which is a felony.
Judge,
So, what's your position on this?
briefly,
So here, and let me speak a little bit directly to your client, okay? And I don't know exactly what the relevance would be, so maybe you should tell me first what your position is.
Judge, we have already elicited testimony, and there is testimony in the record that the jury has heard that items that were purchased at Walmart,
Yes.
items that were purchased at Walmart that night, inclusive of a cell phone and other items that would in fact be contraband, cigarettes, a telephone cable, things of that nature, were meant in fact to go that weekend, the weekend of the murder, to the prison where Mr. Murphy's brother was incarcerated.
Well, I don't think that's come before the jury.
I'm sorry, Judge?
That hasn't come before the jury.
No,
Just the
Judge.
fact that he was at Walmart and was purchasing items, and I don't even remember getting in any detail into what he actually purchased.
I think
It showed him, and like the technology area or the phone area, but I don't remember any specifics yet coming before this jury.
I think, if I'm not mistaken, that Detective Ramos stated that he originally thought that that cell phone could be a burner phone for this particular offense. Come to find out during the course of his investigation, and he's meaning this text, that that's not the case. That it wasn't, that it wasn't for that
Okay.
purpose.
So that's why you saw it originally, and that's why the state originally cropped out the photo, right? There was a photo showing just the photo that the jury has seen was just the shoes, the purported shoes.
Correct, Judge.
Of your client.
Correct.
And then there were other items that were on the floorboard that the state did not include in the photo that went before the jury.
Yes,
Right.
Judge, and in looking at the totality of how
So
this,
let me just ask you this, do you want to seek to admit this or not?
do I
Yeah,
want to
do you-
seek to admit
Yeah.
the text message? In conversation with my client, he wants to admit it.
Okay, so here's the thing, Mr. Murphy, Rashad Murphy. This is what we would refer to as a double-edged sword, okay? I could see how your attorney could potentially argue that this might be helpful to you, but it also could be harmful to you. And the reason why originally I'm assuming your attorney wanted to keep it out is because the state would never be able to introduce this text message in its case in chief against you, because it would be depicting improper bad character evidence on your part potentially. Because attempting to smuggle contraband items into a prison, again, it's a felony. So this would be an admission that you were attempting to commit a felony. So that's why the state could never introduce this as part of its case in chief. Now, if you really think this is important for your defense, after speaking with your attorney, this is your trial, okay? If that's what you really think and that's really what you want to do, then I'll let your attorney admit it. But you need to understand there is downside risks to this. And there may be upside, and the upside may be worth it to you versus the downside, but at the end of the day, it may be only downside, and you just need to understand that going into it. So I just want you to know that, okay? If you feel it's important, I'll let it come in, but you need to understand there's potential downside here. Okay, you want to talk to Mr. Gonzalez real quick about it? Or you know what you want to do? Why don't you just talk to him real quick, Mr. Gonzalez, and make sure what he wants to do. Okay, let me deal with Mr. Murphy first, and then I'll wrap up with you.
Yeah, I think the only thing, I was looking at
Okay, so I tell you what, I'm gonna give them time to continue talking, so what's your remaining issue, Mr.
I
Wise?
think the only remaining issue, I think everything else has been ruled on or worked out, but in the, if you recall, there was a folder that was found in the iCloud somewhere buried deep that was found right before jury selection. That had videos from a club that Mr. Gathright is allegedly at the next night, the one in Orlando. I believe Your Honor ruled that the Don Julio bottles can come in, but there's
Right.
one where he's allegedly doing, it's actually not the correct gang sign, but he's doing the 1200 with the wrong finger, and I think the state would like to admit that. I
Well,
believe,
Let's identify it for the record. What exhibit, what proffered exhibit is it?
Checking, Your Honor. It is a video 94D6, and this is a still from the video. And I, oops, apologize. I can play the video as well for the court, but
Well,
it's
that's
just
okay.
something thrown during the video itself.
Okay, so your argument, he's making a sign.
well,
or
it is the wrong
something.
one, but in any event, he's not alleged to be a gang member. He's not charged with that one. Everyone has said he's not a gang member.
Right.
So I think this, it would be a 403 issue.
All right, that sounds like your argument for the jury. I'll overrule the objection. Okay?
And then the only other issue I think that's left, and this wouldn't really be Ramos, but just keep on court's radar, is that video from Mr. Gathwright's interrogation room where he pushes up a ceiling tile.
Yeah. Is
So
it,
that'll be sometime tomorrow, I assume.
okay. Are you guys seeking to admit that?
Yes, Your Honor.
Okay. All right, we'll deal with that. What
Sure.
witness does that,
Detective Griffin.
Detective Griffin? Okay. Okay, so Mr. Gonzalez, has your client made a decision?
I do remember drafting it.
Judge, after discussion with Mr. Murphy, he is still seeking, admission of what would be Rashad Murphy's defense exhibit number 3, which is the text message.
Okay? Okay?
I just need one moment to speak to Detective Ramos about that. He's been told to stay away from it essentially,
Sure.
and to fix the.
Well, I tell you what, just let him know, because who knows, maybe,
Hold off, yeah.
hold off, maybe during the direct of Detective Ramos, Mr. Rashad Murphy may have a change of heart, so let him know that if Mr. Gonzalez seeks to admit that exhibit, then it's fair game,
Yes, Your Honor.
okay?
Judge, and there is one more issue, connected issue, and that is the picture that was originally redacted. And so at this stage of the game, other than to admit it, which I'm sure Detective Ramos would be able to identify it in order to authenticate it, we do, I believe, already have in evidence the redacted picture.
Okay.
And I don't exactly know how we would handle
Well,
that.
can we substitute the exhibit?
What's been published already, unfortunately, is the redacted version, so I'd be happy to just make another entry. Add it to the list, or add it to that number, whatever is easiest. I'll do whatever.
Or can we get an instruction to the court, instruction to the jury, that they're to consider the new exhibit in substitute for what has already been admitted as?
Oh, I can tell them that this is just a broader view than what they saw. That's fine, and then that way, they don't think anyone's hiding anything from that.
Same exhibit number then, 101L, Your Honor?
What did it come in as originally?
101L.
Then let's make this 101L2, okay?
Nope, I printed another one.
And just remind me to tell the jury that this is just an expanded version of the original 101L,
Yes, sir.
okay? All right.
Judge, and it's gonna be a state exhibit, right? I don't need to introduce it?
Yeah, it's gonna be a state exhibit, and so I guess, but do we want that coming in before you've made sure your client is 100%?
No, Judge, I was just thinking about how do we do it?
Yeah.
Because if we wait on it, then I can certainly make it,
So, yeah, so
Defense
let's do
exhibit
this, let's
3.
do this, let's do this. If your defense exhibit number 3, correct, if it comes in, then at that point in time, we can do a stipulated introduction of 101L2. And I'll just explain to the jury. Okay? Okay, that's what we'll do. Okay, anything else before we put Ramos back on the stand? And you need to talk to Ramos real quick?
Very quickly, Your Honor, yes.
Sure.
And I need to make an edit to the PowerPoint, which has those exhibits, to take out this updated photo.
Okay, so let the jury know we're almost ready, so 5 minutes. All right, we'll go ahead and swear you in one more time, Detective. Please raise your right hand.
Do you solemnly swear or affirm that the testimony you're about to give in this class will be the truth, the whole truth, and nothing but the truth, self you got?
I do.
Okay, very good. You may proceed.
Thank you. Welcome back, Detective Ramos.
Good afternoon.
I want to start talking with you a little bit about the cell phone extraction from the device of an individual by the name of Darius Fields. How is it that you came to know there was relevant evidence related to that individual?
Yes, I learned from Christopher Dre back in Jacksonville that both of the Murphys were attempting to use Darius Fields as an alibi during the weekend of the homicide. So we obtained those Darius Fields phone download to see if we can cooperate that.
Yep. You may proceed.
And sir, did you have an opportunity to receive that extraction from Detective Drebeck as well?
Yes,
Did you take it upon yourself to also review the content of that extraction?
yes, I did.
And what did you do with the information contained in that extraction to prove or disprove any of the information that you had received?
I researched through the data and obtained some information from within the phone that contradicted Mr. Beals being in Tampa.
Were you able to select specific dates in order to do that?
Yes.
What were the dates that you utilized of importance?
June 22nd, 2024, and June 23rd, 2024.
The date of the homicide in this case being the 23rd, early morning hours?
Yes.
As it related specifically to Mr. Murphy, at what time did you expect to see Darius Fields' device in Tampa? Rashad Murphy, excuse me.
For Rashad Murphy in the morning hours of the 23rd.
As it related to the statement from Defendant Davion Murphy, when did you expect to see Darius Fields' device in Tampa?
The afternoon hours of the 23rd.
Your Honor, at this time, the state seeks to admit state's exhibits number 86 and 147A through C.
I'm sorry, that was 86 and
147
A through E?
A through C.
C, okay. Any objection, Mr. Gonzalez?
No additional objections, Your Honor.
Okay. Any additional objections, Mr. Sonardi?
No, Your Honor.
Mr. Wise? Mr. Petrides? Be admitted? Okay.
Publishing state's exhibit number 86, Your Honor. Sir, could you please tell us what exactly we're looking at here?
So in this exhibit, what I did was from Mr. Beals' cell phone, I extracted all of the GPS location, so the store is storing GPS data in it for a variety of reasons. And I input those GPS locations into a program called CellHawk, which allows us to visualize where the device was for the specific time period, and we're looking at that visualization.
Did you also have an opportunity to review the latitude, longitude points for each one of the responses that came back from that cell phone?
Yes,
And include that in your mapping?
yes.
What is it that we're looking for in State's Exhibit number 86 before we press play?
So what we're looking for here is to see if the device traveled to Tampa, and as outlined before we press play in the green box, it's indicative that all of the data analyzed never left outside of that green box.
Would you mind to stand just briefly for this
Sure.
to explain to us where the green box is that you're referring to?
So whenever you put the GPS location data into the program, it's going to create a box around where those GPS data are contained. And as you can see here in the display, the green box is limited to Jacksonville and north of Jacksonville, and there's no GPS locations in his phone that showed that it went anywhere near Tampa during that time period.
For the time and date stamps at the bottom right of the green box on the screen that we're seeing, is that something that will move around the video as we see the recording?
Yes, so on the right, you can see the starting time, 6:21, going up to the bottom at 6:24. So what you see is all of the data points tracking within that time period, and you'll see some movement of the device throughout that time period.
Did you have an opportunity to place specific markers on the areas of location of importance for your investigation in Tampa?
Yes, so at the bottom left here, by the red and blue pins, those are all our relevant locations in Tampa, to include the Airbnb that the defendant stayed at, and all of the scenes where the victim was tracked at.
Publishing 86. Does the arm to the right indicating the movement that was tracked provide that that device was in the area of Tampa, Florida at any point on June 22nd or June 23rd of 2024?
No, it wasn't.
Did you have an opportunity specifically to look at the image, to look at a close-up of the device location from the relevant dates that you previously indicated?
Yes.
Is that what we're looking at here in slide 2 of 86?
It's correct. So this is just a visualization of what we just watched, however, zoomed in to Jacksonville to where the device was at.
May I just pause it to ask you, each time we see a little flicker with the green writing, is that another point at which the device has been geolocated to that location?
Correct. So every time you see a flicker, that's the device through some form of activity registering the GPS location, latitude and longitude of where the device is at that second.
Have you since become aware of what type of structure is at the location that the device was located?
Yes.
What is that?
That is Mr. Darius Fields' homes in Jacksonville.
And did you ultimately learn that there was a mall located in some kind of proximity to Darius Fields' residential address?
Yes, Mr. Beals lived right next to the Orange Park Mall.
Was there a time at which the location data that was coming from this depicting that the device would have been at the Orange Park Mall as well?
Yes, in the afternoon of the 23rd, between around 4 p.m.
Did you have an opportunity also to prepare what's depicted here, State's Exhibit 86-3?
Yes.
What are you
So,
looking at? Go ahead.
sorry. So this is, instead of the video visualization where you can see the movements, this is just a still photograph of all the GPS points that were plotted for Mr. Beals' phone during the weekend of the 22nd and the 23rd. So every one of those is a hit GPS location of where his phone was at in that specific weekend.
And that includes outside of the time frame that we've seen in the GPS data that we just looked at?
Yes, this is 6/21 to 6/24.
So is there a broader time frame that's included for this particular dot map?
Yes.
And lastly, at 86, is this an example of what the native information that you utilize in creating these maps for us actually looks like?
Yes.
Do you download or input these files in some way?
Yes, so from the cell phone extraction, I would export this data onto an Excel sheet and then load it into CellHawk, and it would register specifically the latitude and longitude to plot those points on a map.
Now for State's Exhibit 147, in addition to the extraction of the location information that we've just seen, you can have a seat.
Yep.
Did you have an opportunity to analyze the actual content on the device itself?
I did.
And in analyzing that information, what types of evidence were you looking for?
We're looking for evidence of who's possessing the phone at the time, and that could be digital files, whether somebody's taking selfies, or also how they're accessing the phone, whether they're putting in a passcode or whether they're using biometrics like a facial scan to open the phone. All that data would be in the extraction for me to look at.
Looking first to 147B, over the course of June 22nd, June 23rd, and June 24th of 2024, did you have an opportunity to determine whether there were photographs on Darius Fields' device that we just saw tracking for?
Yes, approximately 8 photos that appeared to be selfies found within that weekend. And Mr. Darius Fields is depicted in those photos, and all of those photos had a reference time of throughout that weekend.
On the second page of 147B, are these additional photos from the time frame June 22nd through June 24th?
Yes.
Did some include, for example, if we look at the top of the image that's on the screen now, the second page of 147B, some also included movies or videos, action images?
Correct.
Okay. And is this something that you would have done to further establish the actual possessor of the device, not
Correct.
just the location?
Yes.
Lastly, the third page of 147B, are these the last 2 photos that were also collected from that specific device
Yes.
within that time frame?
Yes.
Specifically at the image on top, 6/23 of 2024 at 12:22 a.m. Has that been adjusted to Eastern Standard Time?
Yes.
At 12:22 a.m. was this photograph documented on this particular device?
Yes.
In 147A, is this an example if you put just one of those latitude or longitude points into the software we've discussed?
Correct.
And what are we looking at here? What did you put in or plug in?
So specifically, I put in just one hit on the phone from the 23rd, and it was at 2:04 p.m. Eastern Standard Time, and it showed that the phone was at the position latitude and longitude, and that specific latitude and longitude is Mr. Darius Fields' home.
When you provide the exhibit or the extraction, such as what we're seeing on the screen, do you have the ability to actually zoom into that pen and look at different locations as well?
Yes.
Lastly, in addition to the photographs, did you search for biometric information on Mr. Beals' device?
Yes.
Can you explain to the jury what that is?
So this is specifically a log For the June 23rd, so the day of the homicide, starting in the morning and going into the afternoon. And what I found was at least 34 times a biometric feature was used to unlock the phone. This specific phone was an iPhone 11, so the only biometric feature that the iPhone can utilize to unlock it is a facial recognition scan.
Did you go through that process in the entirety of June 23rd of 2024 for Mr. Beals?
Yes.
And is that what we're seeing here, pages 1 through 4 of the biometric information?
Yes, starting at 9:41 a.m. and going down in chronological order.
Prior to that, had you seen any entries of unlocking the device?
No.
Prior to 9:41 a.m.?
Not by biometrics, no.
At the conclusion of your review of that information from Mr. Beals' device, did you draw your own conclusions regarding the statements that were provided to law enforcement by Rashad Murphy and Davion Murphy during the course of their interviews?
Yes, I did.
Was the device of Darius Fields or any information to support the person of Darius Fields was in Tampa on June 23rd of 2024?
There's no evidence that Mr. Beals or his device were in Tampa on June 23rd, 2024.
I want to move now back to your investigation, if I may. Can you see the screen in front of you? Not yet. Can you see that?
Yes.
All right. Did you, as throughout the course of your investigation, having collected the relevant evidence in this case, document essentially a timeline of events between the defendants in this case?
Yes, I did.
First, on the date that each of the defendants had been arrested, what is the process for booking them into custody?
The process, I'm sorry, repeat the question one more time.
How are they booked into custody? What happens when they go to the jail?
When they go to the jail, typically what would happen is they would get a booking photograph and their fingerprint scanned, so the jail would obtain all identifying information to get them booked into the jail.
Did you have an opportunity to review specific booking photos for each of the defendants seated before you today?
Yes, I did.
And would that include Davion and Rashad Murphy,
Yes.
Sean Gathright,
Yes.
and Isaiah Chance?
Yes.
Did that also include co-defendant Alicia Andrews?
Correct.
Your Honor, at this time, the state seeks to admit states 98A through D.
Okay, any objection?
No objection?
Mr. Wise? Mr. Petridis? Admitted?
Are these, or do these photos fairly and accurately represent the booking photos for each of the defendants that were captured when they were booked into the Hillsborough County Jail?
Yes, they do.
This would have been after transport from the county from which they were arrested in, correct?
Yes, these photos are all from the Hillsborough County Jail.
In speaking about the portions of your investigation where you collected certain types of evidence, were there social media accounts that you wrote search warrants for and subpoenas to?
Yes.
How does that process work?
So typically when we identify a social media account belonging to a suspect that we're investigating, we start off by writing a subpoena to the what holds the data for that account. So if it's Instagram, it could be Meta or Google. So we write a subpoena. The company then returns identifying information for that account, and from there, if we develop probable cause, we can write a search warrant in order to get more information or more data, specifically content, messaging, things like that.
Did you have an opportunity to do that for the victim, in this case, Charles Jones?
Yes.
When you wrote a subpoena, were you provided with sufficient responses to be able to obtain a search warrant as well?
Yes.
Was that search warrant approved?
Yes.
Did you run that same process for defendants Rashad Murphy, Isaiah Chance and Sean Gathright.
Yes.
Why did you not run that process for defendant Davion Murphy?
I was unable to locate a Instagram account or social media profile for Mr. Davion Murphy.
And at the time, had you done the same thing for Alicia Andrews?
Yes.
Looking first to the social media account for Foolio, or Charles Jones. You already previously testified about having screen recorded the account from the day of the incident, is that correct?
Yes.
Would obtaining a search warrant allow you to get more information?
Yes.
What kind of information do you get that's more than just your screen recording?
So what we're going to see with a search warrant is all the metadata from the company, which will include things like the location or time and date. Sometimes you get location, sometimes you get content. Specifically, we like to see if we're referencing a post, the exact date and time down to the second when that post was made, so we can fit it into the timeline, understanding it better.
Were you able to capture posts from both before and after the time of Charles Jones's death?
Yes.
At this time, Your Honor, the state seeks to admit states 95F, I believe 95A through D have previously been admitted.
Okay, any objection to 95F? Mr. Gonzalez?
95F?
Yes.
Is that gonna be just a new exhibit?
Yes, sir. It is not, it is from the list from today. That's right, it's just the first page.
No objection, Your Honor.
Okay, Mr. Sonardi?
No objection.
Mr. Wise?
Certainly, Judge, said,
Subject to renewal of all previously made objections. Any new objection? No. Mr. Wise, any new objection? No, Your Honor. Mr. Petridis, any new objection? Okay, be admitted.
And sir, you previously indicated that you had an opportunity to screen record the victim's Instagram posts from the early morning hours of the homicide.
Correct.
At the time that you completed this screen recording, so in the hours after the murder, did you have the post that occurred 24 hours or more in advance?
I had the post that occurred within 24 hours of me viewing it, and not the ones made before that.
Not the ones made before that.
Yeah.
Did you know anything or have any information at the time that you viewed this account about what Charles Jones was doing before the posts that were on his social media account?
The only information I had was starting with Friday night, the 21st. Before that, no.
When you received the return from Instagram on the search warrant that was executed for Mr. Jones's records, did you receive stills and the actual video clips like what we're seeing here?
Yes, correct.
And on the stills, for example, of this particular post, I don't even drink this ain't me, this post itself, would you have also had data which gave you date, time, those types of things?
Yes,
Is that something that you don't necessarily get with the screen recording itself?
correct.
Are those returns in UTC as well?
Yes,
And is this 95A what we'd previously seen as the Airbnb and posts from victim Charles Jones's account before the homicide?
correct.
Did you have an opportunity? Sorry about that. Did you have an opportunity to write search warrants and obtain returns for Instagram accounts for Rashad Murphy, Sean Gathright, and Isaiah Chance?
Yes.
Under the names of what? Specifically for Rashad Murphy?
Ghost 187 with 7 underscores after it.
And for Sean Gathright?
This one's at with the number 5, Andre Chandre.
And lastly, Isaiah Chance?
Yes, double G Gutazade.
Your Honor, the state seeks at this time to admit states 87A through E.
Okay, other than previously made objections, any new objections, Mr. Gonzalez?
No, Your Honor.
Mr. Sonardi?
No, Your Honor.
Mr. Wise?
No, Your
Mr. Petridis?
Honor.
Okay, they'll be admitted.
Your Honor, my apologies, 88A through F and 97.
Okay, one more time, 88, A through F, and 97.
Yes, 87, 88, 97.
I'm sorry, wait, 87, 88,
3 total exhibits, Your Honor. 87 A through E,
okay,
88 A through F,
okay,
and 97.
97, okay. Any objection to these, Mr. Gonzalez,
Just
other
the
than
one photo.
previously made
No, Your
objections?
I mean, the account info, but just the one photo.
Mr. Sonardi?
No objection.
Okay, Mr. Wise?
No objection.
Mr. Petrides? These exhibits will be admitted.
Did you have an opportunity to review the content from the returns on the exhibits you just mentioned
Yes,
from Instagram itself?
yes,
Did you capture the time frame as was charged in the indictment in this case in reviewing that content?
correct.
And did you pull items of potential evidentiary value from your analysis of the evidence that was included in the return from Meta?
Yes.
What specific time frame did you utilize?
Specifically, June 1st to June 24th.
Did you have reason to include that specific amount of time or that time frame?
Yes, we had evidence that there was a conspiracy or the thing coming in play even before the weekend of the murder.
Turning now to the actual cell phone records, how do the cell phone records differ from the records that we've just discussed from Instagram?
So the cell phone records are going to be tied to the cellular device and specifically the companies that service those cell phones to provide them a connection. Typically AT&T, Verizon, T-Mobile, companies like that. Instagram is a social media account, whereas in the cell phone records, they're going to be called detail records and cell site engagements directly from the cell phone provider.
Do you get additional information, call logs, subscriber information on the returns from cell phone records?
Yes.
And did you have an opportunity to obtain the cell phone records with the information that you've just testified to for each of the defendants in this case?
Yes.
Your Honor, at this time, the state seeks to admit states 75A through D, 101A, 73A through D, 72A through D, and 71A through D.
All right, other than previously made objections, any new objections, Mr. Gonzalez?
No, Your Honor.
Mr. Sonardi?
No, Your Honor.
Mr. Wise? Mr. Petrides? Okay, admitted.
And lastly, Detective, did you have an opportunity to seek returns from something called iCloud?
Yes.
Can you explain to the jury what that is?
So iCloud is a kind of a remote storage that Apple uses to store data from your phone if you have an iPhone or an Apple product. If we don't have a physical device to do an extraction from, the next best thing would be to try to get a iCloud backup in case you've backed up your data from that device onto the iCloud.
Are those backups relevant only in relation to the last time the device was backed up?
Correct.
And what types of information are included on those backups?
So it could be a substantial amount or limited. It all depends on what the user has preset. So some people only back up, say, photos or videos. Some people back up the context of messaging. So it all depends on what the user has determined they want to back up. But it could be a substantial amount of data that would be found on your phone.
Were you able to obtain a full iCloud return from Davion Murphy's cell phone number?
I got an iCloud backup. It wasn't full, though.
How do you know when you review the content of it whether the device information or the backup itself is full?
There would be missing pieces, so specifically there was no messaging for the period requested, so that's indicating that that user likely didn't have his iCloud set to backup messaging.
What's the legal basis?
He's been qualified as an expert. He's giving opinion, not saying fact, Your Honor.
Okay, rephrase.
In your review of the cell phone extraction for Davion Murphy that was returned from Apple, Did you see any text messages?
No.
Did you see a significant amount of photographs?
Yes.
What about video evidence?
Yes.
And were you able to view subscriber information connected to the return itself?
Yes.
Is there a software that you use to review all of the returns that come back from iCloud?
Correct.
What is that software?
Cellbrite.
And how do you use that when the information comes to you?
So the data comes from Apple, and then that data gets put into Cellbrite. It gets parsed out so that we can view it, basically, so that I can conduct a search of the data in a viewable form to see the photos or any other data that's in that iCloud account.
The data that actually is received initially, is it something that's in a readable format for you?
No, it's raw data.
And so is Cellbrite a software that your agency utilizes?
Correct.
Did you do the same for a return from Sean Gathwright's device?
Yes.
And from the device of Sean Gathwright, were you able to obtain a full extraction?
Not a full one as well.
What about from Isaiah Chance?
I got an account, but not a full one, no.
And lastly, Miss Alicia Andrews?
Same thing.
When you opened the extractions or utilized the software to open these extractions, were you able to view subscriber information?
Yes.
And did you have returns on iCloud accounts that you reviewed specifically for all of the 4 defendants previously
Yes.
mentioned? Your Honor, at this time, the state seeks to introduce Exhibits 134, 135, 136, 138, 94, and 75.
All right, other than previously made objections,
No new objections, Your Honor.
okay,
So no objections.
Mr.
Just a moment.
Sure.
No further objection.
Okay, Mr. Petridis? Okay, all previously made objections are renewed and they will be admitted.
All right, sir, I'd like to start, Detective, with Sean Gathwright. Can we do that?
Yes.
His account returns, you indicated you had an iCloud account for Mr. Gathwright, is that correct?
Correct.
Did you have a phone number that through the course of your investigation you were able to confirm belonging to Mr. Gathwright?
Yes.
And did you link that phone number to a cell phone provider?
Yes.
Did you also link Mr. Gathwright to a social media account?
Yes.
In reviewing Sean Gathwright's returns from each of those account holders, were you able to confirm an email address or multiple email addresses associated to Mr. Gathwright?
Yes.
And was there any timing specifically related to the returns that you had for Mr. Gathwright having multiple email accounts?
Yes.
What was that significance?
One of those emails accounts was created post-murder.
Was the rock out Sean with double letters at iCloud.com email account utilized in the new device that was located by law enforcement subsequently on a search?
Yes.
The rock out Sean account was?
I'm sorry. One was before, one was after.
Okay, I'm sorry. So the Redman 5 was the after?
Correct.
Okay,
Yes.
thank you for clarifying. I apologize if I was confusing. Did you have an opportunity to review the returns from the Instagram?
Yes.
Were there a significant number of items from the Instagram returns, starting first with State's Exhibit number 97, that were actually relevant to your investigation?
Yes.
What, if anything, was relevant to your investigation from the Instagram return?
I'm sorry, for Mr. Gaithwright specifically?
Just gonna start with
yeah, no, there wasn't much in his Instagram that was relevant.
Were you able to preserve or confirm the email address that was utilized to create that account?
Yes.
And was that same email address utilized in the iCloud records that you reviewed?
Correct. So we can see under account identifier, rockoutshawn at iCloud.com was an email address that we had in common between his Instagram and his iCloud account.
And still states number 97, were there any other photographs other than the profile picture depicted or information that were obtained from this particular extraction?
No.
Did you execute then a search warrant for the iCloud records and review the content that was returned with those?
Yes.
For iCloud, if an email address or phone number is registered to more than one account, are you able to obtain more than one account?
Correct.
In states 97, 136, and 138, did you obtain multiple returns from Sean Gathrigh's iCloud search warrant?
Yes.
When Apple provides you multiple returns, do you have the opportunity to actually go through the content from each one?
Yes.
In this particular case, did you review the contents from the rockoutsean at iCloud.com and the redman5x at iCloud.com?
Correct.
Did you have a physical device with information from the date and time of the homicide to review related to Sean Gathright?
No.
Was this search warrant returned to iCloud the data or information that you obtained or retrieved from that, from the iCloud, whatever had been backed up from the device?
Yes, so specifically, we don't have the physical device, but the data that we're viewing on the iCloud is from that physical device that would have been in his possession during the specific time period.
Were you able to check the date and timestamps to confirm such?
Yes.
And was that related to the iCloud account of Rockout Sean?
Yes.
Were you able in the returns to confirm a phone number?
Yes.
Was that phone number utilized across other platforms as well?
Yes.
Did you cross-reference the phone number for this account?
Yes.
And did it match the phone number utilized in this case for Sean Gathright?
Correct.
Did this phone number also appear in the cellular records for Mr. Gathright?
Yes.
Did this phone number appear in the cellular records for Mr. Gathrit's co-defendants?
I'm sorry, is it communication with him?
Yes.
Yes.
Did you obtain this return in 73B from AT&T for defendant Sean Gathright?
Yes.
Were you able to confirm the identifiers for the user of that device in that return?
Yes, so this is from AT&T. Well, for that, when I send them for the subscriber information for that phone number, they sent back a subscriber information so we can identify who that phone number belongs to. Specifically, they put the name as Sean Gathright.
Related to this specific return, did you also get other types of records?
Yes.
Like what?
Call detail records, timing advance, and CDRs with cell sites, so cellular location data.
What is a CDR or a call detail record?
Call detail records will be at any time that you're utilizing the actual network from your device. So AT&T, specifically mostly text messages and phone calls. So if you dial a phone number or send out a text message and it goes through AT&T's network, it would be registered in call detail records.
What about if you did FaceTime on Wi-Fi?
No, so because like if you did iPhone to iPhone, that would utilize Apple's networks or the internet through Wi-Fi, so that wouldn't be registered on call detail records at all.
Is that the same for iMessaging and text messages?
Correct.
What's the difference in those two?
So again, iMessaging is utilizing Apple's network, so it would not be registered on AT&T's call detail records.
Is there another way within the device that you are able to retrieve or recover iMessages?
Yes, so if we get the iCloud dump or backup and the messages have been backed up to the cloud, then we would be able to see the messages that way from Apple directly.
Did you have an opportunity to obtain records related to specifically Isaiah Chance?
Yes.
Our Mastermind one-on-one at iCloud, was that related to an Apple return that you received from Apple for Mr. Chance?
Yes.
Did you also receive guttaze42 at Gmail as a return from Apple?
Yes.
Are you able to use email addresses other than iCloud.com when utilizing Apple's iCloud service?
Yes.
Okay, and what happens when you use the iCloud again? Where does the information go when you're using iCloud?
Specifically being stored on Apple's servers remotely.
And you were able to complete a search warrant in the return based on the phone number itself?
When we send the phone number off to the cell phone provider, they let us know what device was being utilized, and because an iPhone was being utilized, that gets us to Apple.
Did you also have account returns for additional items for evidentiary value related to Mr. Chance?
Yes.
What about double G guttaze or G guttaze? Were those account names utilized in this case on your returns for Isaiah Chance?
Yes.
And lastly, Mr. Rich Off War, was that an account name utilized for Mr. Isaiah Chance on the returns that you obtained?
Yeah, that was, I believe, Cash App for that one, yes.
And starting first with 87B, did you obtain an extraction from Instagram for G Gutta Z?
Yes,
Did you review the contents of that extraction?
yes,
Contained within that extraction were there profile images?
yes,
Also contained with that in that extraction, is there identifying information that you're looking for?
yes, subscriber information, any email addresses or phone numbers.
In 87A, was that information recoverable from the Instagram return records for Isaiah Chance?
Yes, we got a vanity name, the email address, and a phone number.
Were you able to link this email address to that account based on the return from Apple as well?
Yes,
What about this phone number that's linked to the account as verified? Were you able to identify the phone number that was ending 7534?
yeah, that was an old phone number for Defendant Isaiah Chance.
Were you able to subpoena records to confirm that that was an old phone number that had been utilized?
No, it was no longer his phone number.
Had you, in the returns from your applications for a search warrant or subpoena to other accounts linked to Isaiah Chance, reviewed that number as an old number that was utilized?
Yes,
Specifically in iCloud, did you have an opportunity to review the contact information or the location information related to Isaiah Chance?
yes,
Was the number that had been utilized previously by date and time as it was registered with iCloud depicted on the returns?
yes,
And is that 7534 number that was utilized to create the Instagram?
correct,
And did that number ultimately change?
correct,
Did the residential address for those accounts remain the same?
yes,
In looking at that iCloud account itself, were you able to confirm the address that was returned on the iCloud return as being a legitimate address for Mr. Chance?
It was one of the addresses historically listed under his driver's license information, correct?
And did you obtain the records on the right from another subpoena to Cash App, the image specific?
That image specifically came from Cash App. Cash App requires a user to upload a picture of their ID.
And was this the ID that was utilized in the Cash App,
Correct.
or at least provided to you from the Cash App return?
Correct.
Your Honor, at this time, the state seeks to admit State's Exhibit number 93.
Okay, any objection, Mr. Gonzalez?
No, Your Honor.
Okay, Mr. Sonardi?
No, Your Honor.
Mr. Wise? Okay, Mr. Petratus? Okay, no new objections, it'll be admitted.
And then, sir, did you have an opportunity to review the actual phone record returns for the same individual, Mr. Chance, when the subpoena returned back from AT&T?
Yes.
Was AT&T the provider for the cell phone device or information for Isaiah Chance?
Yes.
And were you able to confirm that information in your review of those records?
Correct.
Were you able to confirm the active number at the time of your homicide is the number depicted ending in 4707 here?
That is correct.
Rashad Murphy, did you have an opportunity to complete the same for Rashad Murphy?
Yes.
With the exception of the cellular device, did you actually obtain a search warrant for the Instagram account linked to Mr. Murphy?
Yes, I did.
And what about the Gmail account itself?
That was a subpoena for subscriber information.
Did you obtain a return on that subpoena?
Yes.
And did you have an opportunity to review the content on the return from that subpoena?
Yes.
Starting first with the Instagram records at State's Exhibit 88A for this account. Ghost187 official, is that an email address used to make this account?
Correct. So when you set up your Instagram, you don't have to submit too much information. In this specific Instagram account, the only subscriber identifier that they gave us was a vanity name, Ghost187, and then the registration email address, the email address the user used to create the Instagram account.
And I've kind of condensed or tried my best to condense it to a slide, but do you receive a significant volume of information on your returns from Instagram?
Yes.
The metadata?
Yes.
Do you then go through that information searching for dates and times that are relevant to your case?
Correct.
Did you do that in this case with Ghost187, the Instagram account?
Yes.
Your Honor, at this time, the state seeks to admit State's Exhibit number 108.
No new objections, Your Honor.
Okay, any, other than previously made objections, any new objections, Mr. Sonardi?
No objection, Your Honor.
Mr. Wise? Mr. Petridis? Okay, that will be admitted.
Did you have an opportunity at this point to review the screen recording from the account Ghost187 on Instagram?
Yes.
And could you see any identifiable markers at that point?
No.
No photos or pictures that identified the account holder?
No.
What steps did you take when you actually received this Instagram return to identify the account holder's information?
Being that all we had was a registration email, since it was a Gmail, what I did is I subpoenaed Google to have them give me subscriber information on that Gmail to see who the owner of that Gmail was in an attempt to identify the owner of this Instagram account.
When you reviewed the screen recording or looked at the account itself, was there a legal or recognizable name that was utilized in the profile that you could potentially search?
No.
Was a name listed on there?
No.
On the profile itself, in the descriptor area, was there a name or words listed?
I'm sorry, for Instagram or Gmail?
Yes, for Instagram.
No. I'm sorry, you gotta rephrase the question.
On the Instagram account itself, the screen recording that you received from Detective Draven
Yes.
of Ghost187's account after the homicide.
Correct.
You with me?
Yes,
Okay.
sorry.
No, that's okay. In the descriptor location under the profile picture,
Yes, there
was
was
there
a,
some paragraph about a descriptor?
yes, there is.
Were there names or words written in that descriptor paragraph?
Yes, correct.
Were there any legal government names or identifiable persons that you could find in the course of your investigation that were listed there?
I believe so.
A name of an individual?
Not a legal name, no.
Okay.
There was a name in there, but it wasn't a legal name that I could attribute to anybody.
You actually searched for it, is my ultimate point.
Yes, correct.
When you obtained the returns in State's Exhibit number 108 from Google, were you able to look at the proprietary information for the billing info on the account that we've discussed?
Yes.
Ghost187official@gmail.
Yes,
Is this the account that was utilized to create the Ghost187 Instagram account?
correct.
And what information was of significance to you on the Google returns?
So because of the use of different kinds of names that might not be legal names or might be aliases, I focused in on the Google Pay information that was attached to that Gmail because you can't utilize a fake name or an alias or not a real name, specifically when it comes to Google Pay. And the Google Pay account linked to that Gmail had the person's real name, which was listed in the return as Rashad Murphy.
The Google Pay information also includes additional information as well.
Correct.
So did you have an opportunity to review it in its entirety for the financial institution types or the card numbers, that kind of thing?
I've reviewed their return, yes.
And in your review of the return from Google, were you able to determine who that email account was registered to?
Yes,
Who was that?
Rashad Murphy.
And lastly, for Mr. Davion Murphy, were you able to confirm the phone number associated to that account?
Correct.
Was 108 admitted?
I believe so, 108?
It
Say
wasn't.
that again?
She did ask, but it hasn't been admitted yet?
Oh, I apologize.
Okay, any objection to 108, Mr. Gonzalez?
No new objection, Your Honor.
Okay, Mr. Sonardi?
No objection.
Miss- Okay, Mr. Wise? Mr. Petridis? Admitted.
Did you do the same with Mr. Davion Murphy's information?
Correct.
How did you come to gain the information for his assigned phone number?
That specific number showed up in Rashad Murphy's CDR records.
The call detail records.
Correct.
So you had reviewed the returns from the cell phone providers,
Yes.
and what did you do, or what were you looking at specifically in reviewing those returns?
I was looking for phone calls that they would have made during the relevant time periods, and I found this phone number and ran it in the system, and it came back to Davion Murphy.
Had you had other information, or were you developing other information at that time based on the course of your investigation that also made Mr. Murphy a suspect in your case?
Yes, specifically a photograph from Rashad Murphy's device that had a picture of his ID in it.
Did you also have the data or download from the Ring camera at the Airbnb location?
Correct.
Did you obtain a subpoena for the records from T-Mobile?
Yes.
And did you ultimately seek a return from the records for T-Mobile for the device assigned to Davion Murphy?
Yes.
Was an email address also provided for Davion Murphy?
Correct.
The state would seek to admit, if not previously admitted, state's exhibit number 134. I believe it should be in.
State, excuse me, Mr. Gonzalez, any objection?
No, Your Honor.
Mr. Sonardi?
No objection.
And Mr. Wise? Mr. Petridis? Okay, that will be admitted. And just so you know, I told the jury 6, we're gonna go to 6:15, and then that's it for the day, okay?
Will you just yell when you're on her?
I shall.
Thank you. Did you have an opportunity to review the records that were provided in State's Exhibit 134B, the return from T-Mobile?
Yes.
Publishing 134B, is this the subscriber information page that T-Mobile had provided to you?
Correct.
Were you able to establish a relationship between the defendant and an individual by the name of Serena Beeks? Or was there some relationship between the two?
Family?
And the subscriber name, did it reflect Davion Murphy?
No.
Throughout the course of your investigation or speaking with other law enforcement officers, did you determine or were you able to learn of the significance of the subscriber name utilized to create this account?
Yes, specifically Suge and Spaz are nicknames to people who died in the war.
Did you have an opportunity to obtain an iCloud return as well for the email address that was utilized to create the accounts?
Yes.
And was that Davion_Murphy44@gmail?
Correct.
I'm going to publish states 134, B. Is the return also able to give you any additional information regarding subscriber information?
Yes.
Was there a different name utilized in 134B for the return from iCloud for the subscriber?
Yeah, it appears to be another fake name, Poopa Cutway.
Did you have an opportunity to observe whether the email account that was utilized for both the cell phone and the iCloud return were the same?
Yes, Davion Murphy 44@gmail.com.
And was the number utilized to register both also the same?
Correct.
Throughout the course of your investigation, was the number ending 3137 attributed to Defendant Davion Murphy?
Yes, that is correct.
Your Honor, I believe the next portion is actually when we actually dig into the timeline, so it may be a better time to stop.
Sure. Okay. All right, very good. So, members of the jury, we're going to have our evening recess. We will reconvene at tomorrow at 9 a.m. Just remember my previous instruction, you're not to discuss anything about this case with anyone, read, watch, listen to any news or social media posts, and you're not to do any independent investigation. So, just so you know the schedule, we are working towards the conclusion of the evidence happening sometime Wednesday. Thursday, we would come back for closing arguments, and then Friday morning, you all would come back for the final instructions on the law, okay? So my plan is to attempt to send the case to you Friday morning, all right, just so you know. And so that may mean we may have to work a little bit past 5 these next couple of days to get the evidence in and done, but we are making really good progress, and I just want to thank you all so much for your patience with this, and we're almost there, all right? Very good. See you tomorrow at 9 a.m.
All right. All yours are all good.
Okay, very good. All right, everyone, see you tomorrow morning at 9 a.m. I have a quick matter and another death penalty, 3851. It'll take me just 2 minutes in the morning at 9 a.m. and then we'll get going, okay?
Thank you, Judge.
Detective Ramos, same thing. You, again, on the stand, you've not yet been cross-examined. You can't talk to anybody, including the prosecutors, about anything related to this case, okay? All right, see you tomorrow morning at 9 a.m.
Maybe like,
Yeah.
whatever. 9 a.m. Get a blanket.
Yeah, no, it's fine.
Yeah, I don't know.